Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. I'm one of your hosts, Marcy Dixon. We're going to jump right in and continue a conversation about arbitration with Miles neutrals Matt Thiry, Jennifer Grippa, and Steve McKinney. If you haven't heard our previous episode, check out Winning in Arbitration Part 1. So Matt, arbitration was created to be an alternative to the lengthy, expensive, and public process of litigation. But somehow, which you've illuminated in this podcast and in our last episode, that it is no longer what it used to be. Can you speak to the unfair bias associated with arbitration?
Sure. I think it's almost unfair to have an unfair bias in arbitration if you really think about it, because the purpose is to have a neutral, by definition, to work out the parties' dispute and come to a conclusion. Unfortunately, I think because the arbitration process is a product of a contract, parties have an opportunity to take advantage of another party. And when a lawyer drafts a contract, they're always keeping their client's best interests in mind when they're drafting that contract, and not necessarily the overall fairness of the situation. They're sort of relying on the other party or the counsel that represents the other party to kind of push that fairness back into the process. And a lot of times, unfortunately, the arbitration clause is looked at as boilerplate in a contract and is somewhat glossed over, either by the attorneys that are negotiating the contract or when an attorney is not involved in the contract by the parties. They just look past that because it's not the meat and potatoes substance of what the contract is about. They have another alternative business purpose that's the primary purpose for that contract. So instead of spending the time necessary to make sure that if there's a dispute that they're going to have it handled in a way that makes sense to them, they somewhat look past it, wait until there is a dispute, and then they're sort of stuck in a situation where they gave up rights in their contract and they're now being forced to go into this arbitration process that can be slanted. And the slant or the bias that comes into this process is, a couple of examples would be arbitrator selection or arbitration forum. Especially when you have contracting parties that are in different locales, you have the ability to pick a locale for the arbitration. If you're in Georgia entering into a contract with a company that's in New York, do you really want them to be able to pull you into an arbitration in New York as opposed to having to come to Georgia? That's a significant change, not just in the substantive law that's applicable to the situation, but it's a substantive change for you in convenience and cost. Having to deal with counsel you're not familiar with, having to travel to an unknown area to handle your dispute. The other part that I mentioned is the arbitrator selection process. And that is, I think, probably the one thing that probably is weaponized the most in the contracts. And what I mean by that is the parties, especially if you have a party that has significantly superior bargaining power, have a tendency to want to pick an arbitrator that they think is more sympathetic to their side of the story. And obviously, if you come into a dispute and you're that other party and you realize that the arbitrator is more sympathetic to the other person's story before the story is even told, you're not feeling very good about arbitration. And the lawyers that are representing you probably aren't feeling very good about arbitration. So that there's the unfairness that comes into the process that's not a part of the original intent of arbitration, but is a byproduct of the contracting parties taking advantage of each other.
Steve, in our last episode, you mentioned a situation recently where you combined 5 arbitration hearings into one, which frankly speaks to your creativity and integrity as a neutral. Jen and Matt, have there been similar instances where you have had to act creatively in your role as a neutral?
Well, one thing that I saw in private practice, and particularly in construction, was arbitrations that would go off the rails because there was an arbitrator, sometimes in construction matters, where arbitrators are appointed depending on the arbitration company that's contractually agreed upon. Sometimes there is no selection of the arbitrator. One is just assigned to the matter. Sometimes they're not even lawyers. And that can be very problematic because too many times I've seen clients lose control of the process because the arbitrator just lets it go. The arbitrator has allowed people to turn what should be a 2-day arbitration into a 2-week arbitration, one that just keeps going and going because there's no end, there's no structure. I really think that it's important for an arbitrator to maintain the formality of the process and to keep a structure and to keep it streamlined, to have direct and cross and some rebuttal, but not cross upon hours and hours and days of cross-examination and then recross or redirect and then a recross. And at some point, the arbitrator just needs to maintain control and not let some zealous advocates necessarily run with it to the point where, again, you had a 2-day arbitration, it's now a 2-week arbitration, when it really should have just been a 2-day arbitration.
Yeah, and I think to go along those lines, that's also something that needs to be communicated to the attorneys early on in the dispute is, it's not necessarily litigation light, as we've referred to a couple of times. It's distinct in its form, and you want efficiency here. In order to get that efficiency, you guys have to agree that this is the process that you're going to follow. So, do you want to agree to some limitations on discovery, some limitations on how you're going to handle witnesses? Are you going to do submissions instead of live testimony on certain aspects? And those aspects of the process are where you pick up some of these efficiencies. And if you don't take advantage of those, then it does start to look more like litigation light. The fees do start to escalate. Things do come off the rails. The expenses and the time and all the process sort of goes back to litigation with an arbitrator instead of a judge. And you lose all of those efficiencies. I think that's an important thing for folks to understand. And the other thing I think is important also is, control over evidence. You want an arbitrator that's going to control the evidence to some extent, and not in the sense that they're going to exclude evidence that should come into the hearing, but in a sense that it should exclude evidence that wouldn't ordinarily be allowed to be considered for a decision in that type of case. Apply the rules of evidence of some sort, or at least an agreed upon set of rules of evidence, so that everything under the sun is not brought into consideration. If you're trying to control the process and limit the scope, then control the process and limit the scope. But if you think just because it's less formal, because you're not in a courtroom, that the arbitrator should hear everything and anything, then you're losing the point and the benefit of the arbitration process itself.
And a lot of it is having trust in the arbitrator that you've selected. And it's very important to make that decision up front, to select the arbitrator that you know is competent to make the decision in the case. You really don't need, obviously it depends on the facts of the case, but I think some lawyers bring in more and more witnesses, more than they need, more evidence that they need, because they're worried about, will the arbitrator get it? Will the arbitrator understand this? And obviously each side wants the arbitrator to rule in their favor. But you've got to have faith in the arbitrator that you've selected that person because of his or her knowledge and experience and expertise in that subject matter, the ability to cull through all of these facts and evidence and to make the right decision.
Marcia, your reference to the integrity of an arbitrator really doesn't find any greater expression than in an arbitrator's willingness to make an application of law or an application of rules of evidence in a way that might even bring the arbitration to a close. An example is one of my fellow arbitrators here at Miles 2 weeks ago made a ruling in an arbitration that caused the arbitration to end. It basically caused the plaintiff's side of the arbitration to collapse and for the arbitration to end with no recovery to the plaintiff, based on the arbitrator's assessment that the report prepared by the plaintiff's expert wouldn't allow her, in this case, to have that expert testify in the arbitration. She basically made a ruling that the expert's testimony wasn't credible enough to reach a threshold level of relevance and credibility to support the plaintiff's claim. And, the arbitrator did that based on a full and fair assessment of the entire discovery in the case and a full and fair assessment of the potential testimony that the expert to be promoted by the plaintiff was planning to make. Does that work in the economic advantage of the arbitrator? No, it works to the economic disadvantage of the arbitrator because there's no arbitration hearing. If you have an arbitrator, you need to really have confidence at the very beginning that if there is a claim or a defense that is joined by either party, does not have any proof supporting it, that the arbitrator is willing to end that claim or defense without having a hearing just for the sake of having a hearing. There's nothing that will undermine people's sense of the integrity of the arbitration process and to foment more cynicism about arbitration as a fair process than to have a sense that an arbitrator is just having a hearing because that's where the largest part of their professional fees are generated. That's the kind of thing that I think folks who are engaging Miles can have some real confidence that what they're going to get is a full and fair oversight of their arbitration matter by an arbitrator who is committed to helping them manage their dispute, who's committed not just to getting them a result, but getting them a result that they've participated in, and to help them feel like at the end of the process that they've disputed with purpose. They haven't just shown up to let this happen to them, but they've done this in a purposeful way.
Let's touch on arbitration clauses for a moment. How do they factor into this conversation? And what can parties do prior to the dispute to prepare themselves in the unlikely event that they find themselves in arbitration?
My primary observation with respect to arbitration clauses, I was in private practice for 30 years and was involved frequently in helping the corporate litigators and the contract negotiators among my 150 partners in doing some thinking about arbitration clauses, which is really a process of anticipating disputes. An arbitration clause isn't really about, if it's going to be effective, addressing a particular anticipated dispute and crafting a clause that just tries to get its arms around that narrow particular kind of disagreement or dispute that might arise. An effective arbitration clause has to anticipate just about any kind of dispute that might arise under the particular contract that it's incorporated into. And so I quite frequently advised filling the arbitration clause up and making it larger and more fulsome rather than shorter. I've looked at arbitration clauses that were as short as 10 words, and I've looked at arbitration clauses that went on for 3 pages. I don't see any particular reason if I'm advising a client. Again, I'm a full-time arbitrator now, but back when I was advising clients in private practice, I don't see any reason not to have the arbitration clause be very, very complete. Frankly, because the purpose of the clause is really less to manage the dispute, but the purpose of the clause is to get the dispute into arbitration and make sure that an arbitration is initiated. The advices that I always gave my corporate partners to pass on to their clients for whom they were drafting contracts is to keep in mind that this is less about prejudging what's the most efficient and expeditious way to manage a particular dispute. It's about getting the dispute on an arbitration footing effectively and unassailably. And then once you're in that posture, to be prepared to pick and choose in the arbitration clause. There may be things in the arbitration clause that might be best left behind for a particular dispute. That's one feature. The other feature that I consistently asked my clients to consider in putting in an arbitration clause is considering a three-arbitrator panel instead of a single arbitrator, just because in the great sweep of things, if you took 100 disputes that are going to be resolved in arbitration, I think you probably would like to have a little bit of a hedge that if one particular arbitrator might not either like your position or might not be quite as informed or as reasonable, there's a little bit of a hedge in having two other arbitrators to take a look at things and getting a fair result.
And to build on that aspect there with the three panel, the provision should talk a little bit about how you're going to select. Is one party going to select one, the other going to select the second, and the two selected neutrals pick the third neutral? How are you going to mechanically address that? And I think, you got to keep in mind also that, as we've talked about before with the arbitration provisions in the contract, if your particular dispute doesn't warrant having three neutrals handling your matter, then you simply agree amongst yourself that instead of following the contract provision for three neutrals, we're going to select one, and this is how we're going to do it. So it lays a very good groundwork. I think that's the importance of the arbitration clause, is to lay the groundwork of the arbitration, lay a foundation so that you can get yourself to arbitration and provide yourself with a good default in case the parties can't come to a subsequent agreement, but that understanding that what you're really trying to do is get it to that process, because at that point in time, the control can be assessed based on your actual dispute. And, I think, Steve, you said you don't draft the clause with trying to figure out which dispute it's going to be. That in part is because once the dispute arises, you have the flexibility in arbitration to kind of mold your situation and your arbitration together, as opposed to having to fit specifically within this preconceived arbitration clause that you tried to do your best to come up with, but you're not necessarily able to, at that point in time, before any dispute has ever arisen, or anticipate the process that you're going to need for any dispute that comes up later on.
I think a clause that gives you flexibility is important, because if you automatically draft your provision to say any disputes will be resolved by a panel of three arbitrators, when a dispute does arise later on, one side's going to say, this doesn't warrant three arbitrators, let's not do that. And the other side's going to say, well, why? I don't trust you. Why do you want three? We specified three. We're going to do three, even though it doesn't warrant it, because there's just such a level of dislike and distrust and animosity between the parties for them to actually sit down and agree on something that maybe in the best interest of both of them might be difficult to do at that point. And so I think it completely depends on the dispute, whether it would warrant obviously one or three arbitrators, and maybe drafting that clause to say if the dispute is in excess of a certain dollar threshold, it will be by a panel of three unless the parties otherwise agree, or something like that, so that you can be assured if it's a relatively small matter, you're not going to get hit with the other side insisting that you use three arbitrators. The other thing is, I think that people don't really think about when they're drafting these provisions is the arbitration company that they're going to be using. I mean, they may just specify a company that they've heard of or they're familiar with without really knowing what the procedures are going to be or how much it's going to be. And so it's very hard, again, to back down once a dispute comes up from what's written in that clause. So say, for instance, you have a certain company specified in there, a dispute arises. If you say, oh, I didn't realize that company charges $125,000 filing fee for this level of dispute, how about we use someone else? The other side's going to say, no way, this is who we agreed on up front. And so I think it might be better to have a clause that doesn't necessarily specify which arbitrator you're going to use, which arbitration company, and that gives you more flexibility at the time a dispute does arise as to who is best equipped to handle this. Because it really will depend on the facts and circumstances of your case.
More of our The Future of Resolution conversation after this. One of the last great outdoor events before the holidays is coming up. On Saturday, November 10th, Atlanta Legal Aid Society will hold its 28th Run for Justice in Oakhurst. The race benefits the General Operating Fund of Atlanta Legal Aid, and it's a wonderful opportunity to see fellow lawyers and their families on a beautiful fall day. Everyone is welcome, including kids, pets, and jogging strollers. Families, corporate, church, school, and community teams are also welcome. Regular registration is $25 until November 1st. To register for the race and to find out more information, check out runforjustice.org.
A dispute in which there is an agreement that one party is going to owe some kind of recovery to the other party. That is to say, that the life of the dispute has moved on and matured to the place where there's an acknowledgement, either based on discovery or based on just the concessions that made by the parties, that this is no longer about whether one party is going to recover from the other, but how much. That is, this is a Buick or a bread box. If you have a dispute like that, and you have the added feature that the recovery that is in contemplation by the parties is by any reasonable calculation going to be large, particularly if it's going to be potentially catastrophically large. That's a point where the dynamics can really, really be effective in using some form of what I call baseball arbitration. It's a process where instead of having a hearing, instead of going through a very expensive process of developing a record, the parties themselves write down a number and seal it in an envelope, deliver that to the arbitrator with the instructions that the arbitrator opens both envelopes, but does not get to deliver an award that is any different than one or the other. The arbitrator has to choose. Now, the arbitrator doesn't have to choose immediately. I mean, the arbitrator could go back and do whatever kind of deliberation the arbitrator feels like is appropriate. But if in that situation the parties agree that the dynamic that's going to be involved is having an arbitrator pick one of the others of the numbers, it is really extraordinary what happens. I have had a baseball arbitration in which I've served as arbitrators where the numbers overlapped. That is, the party seeking a recovery has sent in a lower number than the party who was going to end up being the paying party. Just because that dynamic where everybody concedes that money's going to be paid and it's going to be a lot of money, everyone is driven psychologically to the middle. Everybody is hedging their downside risk. If you're the party seeking a recovery, you're hedging your downside risk, that if you put too big a number there, that it's a no-brainer, and just because of the size of my number, the other number is going to get picked no matter what it is. And the same kind of risk is involved in the other party who's paying. They don't want to put down a number that's so low that the other number gets picked just because it's not nearly as unreasonable. So at any rate, that's a particular situation in which an unusual or maybe a more unconventional type of arbitration might be appropriate.
The only types of unconventional arbitrations I'd say I have in construction are ones that take place on roofs and in basements, if it's residential, or in office buildings where we're actually on site looking at issues. And I always find that that's most helpful, to actually see the conditions, understand exactly what's happening. I mean, it can be very important to do that versus just sitting in a traditional conference room. Wherever the parties want the arbitration to take place is very helpful. So if you've got an arbitration taking place and you know that you have 7 employees that are going to be testifying in this arbitration, and it's easier as this corporate entity for you to have it take place in your conference room because your employees can walk down the hall versus drive an hour through Atlanta traffic to get there. And you're just thinking about business costs. I mean, time is money. And so you have to think about the cost to your business to have your employees engaged in this, pulling documents, responding to discovery if you're in litigation, or in arbitration, being there to testify, to present evidence and so forth. And so the flexibility, like Matt said, you're not going to have a judge and a jury of 12 come to your office to do this. But the fact that you could have your arbitrator sitting in the conference room and call your employees down one by one to testify can really be some cost savings.
What else would you suggest to parties throughout the arbitration process? Like, what are some other pointers that you can provide before you wrap? What did we not cover?
I think it's critically, although it is certainly within the purview of the parties to decide whether or not they want a record created at the hearing, I always stress to the parties the real importance of counting into their budget as they try to get a fix on what their hard costs of arbitrating are going to be, the cost of having a court reporter create a record at the hearing. The challenge there is that without a record, the arbitrator is left making her or his ruling and award based on notes that the arbitrator takes down, which they can certainly do that. And you can imagine arbitrations that are very brief or simply aren't very involved and don't involve a great deal of testimony or documentation. That might be quite appropriate. But if, as in the typical arbitration, if there's a pretty significant amount of record, both testimony and materials that are placed into the record as evidence, I think you get more than your value out of paying for a court reporter and having a record created that can be reviewed by the arbitrator before an award is written.
I think also the decision as to whether or not you want a summary order or a well-reasoned order. Do you want the arbitrator to basically just, for lack of a better way of describing it, in a paragraph write down the decision, or do you want the arbitrator to, put forth a decision that explains exactly how the arbitrator arrived at that decision? Obviously, there's a cost associated with the latter, and do you find a benefit? Is it with the lack of appeal abilities associated with the arbitration? Is it something that you really feel like you need to have? Is it something that you want to have? Will it give you better peace of mind? And I guess it goes back, to the process for the parties. How do you want this to work? And do you want it just a quick summary order, or do you want something that's going to be, more elaborate but more costly, and but will give you a better understanding of the mental framework that formed the decision?
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast or Spotify and subscribe, rate, and review this podcast. Join us soon for another interesting discussion. Thank you for listening.